State and recognition in international law. 1. Introduction. In international law, the state is the primary subject and the basic unit of the international legal system. For an entity to be recognized as a state and become a member of the international community, it must possess certain essential attributes, such as population, territory, and government. Recognition is the process by which existing states acknowledge a new entity as a state. 2. Definition of a state. According to Article 1 of the Montevideo Convention, 1933, a state as a person of international law should possess the following 4 qualifications. Permanent population. A stable community of people. Defined territory. A specific geographic area with fixed borders. Government. An effective administrative body that maintains order. Capacity to enter into relations. Sovereignty to deal with other states. The Montevideo criteria. Before anything else, the entity must exist in reality. It needs a permanent population, a fixed territory, and a government that actually functions. Without these physical ingredients, recognition cannot happen. Concept of recognition. When a new state emerges, through independence, secession, or merger, other states decide whether to treat it as a sovereign equal. Recognition is the formal act or acknowledgement by existing states that a new entity has fulfilled the necessary conditions of statehood. It serves 2 main purposes. Legal status. Recognition confirms that the entity is capable of exercising rights and performing duties under international law. Political acceptance. Recognition signals the willingness of existing states to enter into diplomatic relations with a new entity. Important case law. Luther v. Sagor, 1921. This is the most important case regarding the legal effects of recognition. Facts. The Soviet government, which was not yet recognized by the UK, seized timber from a private company, Luther, in Russia. The government then sold that timber to a UK company, Sagor. Luther sued Sagor in a UK court, claiming the Soviet government had no legal right to take the timber because it wasn't recognized. Decision. Initially, the court ruled for Luther. However, while the case was being appealed, the UK government granted de facto recognition to the Soviet Union. Principle established. The court held that once a government is recognized, even if only de facto, the courts cannot question its internal acts, like seizing property, for the purpose of internal legal effects. There is no distinction between de facto and de jure recognition. Real-world examples. United States right-pointing arrow declared independence in 1776. Gradually recognized. Now a founding UN member. Bangladesh right-pointing arrow declared independence in 1971. Gained recognition and UN membership in 1974. Flowchart. The path to sovereign statehood. Stage 1. The Montevideo criteria. Before anything else, the entity must exist in reality. It needs a permanent population, a fixed territory, and a government that actually functions. Without these physical ingredients, recognition cannot happen. Stage 2. Declaration of independence. The entity must formally announce its intent to be a state. This is the assertion of sovereignty. For example, the USA in 1776 or Bangladesh in 1971. Stage 3. Recognition by other states. This is where the theories of recognition, constitutive vs. declaratory, come into play. Other states begin to treat the new entity as an equal, allowing for trade deals, treaties, and diplomatic immunity. Stage 4. UN membership while not strictly required to be a state, admission to the United Nations is the ultimate certificate of statehood. Under Article 4 of the UN Charter, admission is granted by the General Assembly upon the recommendation of the Security Council. 4. Theories of recognition. There are two main schools of thought regarding the legal effect of recognition. A. Constitutive theory. Right-pointing arrow: a state exists only if recognized by others. Proponents: Hegel, Oppenheim, Holland. View: a state does not exist in international law until it is recognized. Recognition constitutes or creates the state. Criticism: if this were true, an unrecognized state would have no rights or duties, which is practically impossible in a globalized world. B. Declaratory theory. Evidentiary theory. Right-pointing arrow: a state exists if it meets criteria. Recognition is secondary. Proponents: Hall, Brierley, Fisher. View: statehood exists as soon as the four Montevideo criteria are met. Recognition is merely a declaration or formal acknowledgement of an existing fact. Conclusion: most modern jurists prefer this theory because a state exists even if some countries refuse to recognize it, e.g., Taiwan. Forms of recognition. In international law, the recognition of a state or government typically manifests in two primary forms: de facto and de jure recognition. These modes represent different levels of legal and political commitment from the recognizing state toward the entity in question. De facto recognition. De facto recognition is a provisional or factual acknowledgement. It is usually granted when a new state or government has effective control over a territory and its people, but there is lingering doubt about its long-term stability, its willingness to fulfill international obligations, or the legality of its origin. It is often seen as a preliminary step, allowing for basic diplomatic interactions and trade without committing to a permanent legal relationship. Because it is temporary and conditional, it can be easily withdrawn if the entity fails to maintain control or stability. De jure recognition. De jure recognition is the full, formal, and legal acknowledgement of an entity as a sovereign state or legitimate government. It is granted when the recognizing state is satisfied that the new entity is stable, permanent, and possesses all the essential attributes of statehood, including the capacity to enter into international treaties. Unlike de facto recognition, de jure recognition is considered final and irrevocable. It grants the recognized state full diplomatic immunity, the right to sue in the courts of the recognizing state, and the ability to claim title to state property located abroad. Key distinctions at a glance: nature, stability, diplomatic ties, succession, revocability. Forms of recognition. Express recognition, granted through a formal statement, letter, or treaty. Implied recognition, indicated through actions, such as signing a bilateral treaty, establishing formal diplomatic relations, voting for the new state's admission to the United Nations. Collective recognition occurs when a group of states, like the UN, recognizes a new entity together. Legal effects of recognition. Once a state is recognized, it enjoys several legal privileges. Right to sue. It can file a case in the courts of the recognizing state. Sovereign immunity. Its property and representatives cannot be sued in foreign courts without consent. Diplomatic relations. It can send and receive diplomatic envoys. Treaty making. It can enter into binding international agreements. Succession. It becomes entitled to the property and assets of the predecessor state located in the recognizing country. Recognition of government vs. recognition of state. Recognition of state involves acknowledging a new entity on the world map. It is permanent. Recognition of government involves acknowledging a change in the internal regime, e.g., after a revolution or coup. If the state remains the same, only the government needs fresh recognition. Withdrawal of recognition, de facto, can be withdrawn if the entity loses its effective control or territory. De jure, generally considered irrevocable. Once a state is recognized as a legal peer, that status remains unless the state itself ceases to exist, e.g., through total conquest or merger. Important doctrines of recognition. A. The Stimson Doctrine. Doctrine of non-recognition. Origin. Proposed by U.S. Secretary of State Henry Stimson in 1932. Principle. States should refuse to recognize any territorial change or new statehood achieved through illegal force or aggression. Example. If country A invades country B and declares it a new state, the international community, under this doctrine, will not grant it legal recognition because it originated from an illegal act. B. The Estrada Doctrine. Origin. Named after Genaro Estrada, Mexico's Secretary of Foreign Affairs. 1930. Principle. This doctrine suggests that states should not issue formal recognition of new governments, especially after a revolution. Instead, they should simply continue or break diplomatic relations. Reasoning. Formal recognition can be seen as insulting or interfering in the internal affairs of another country. Is there a duty to recognize? A common question in exams is a state legally bound to recognize another? Quote, the answer is no. Asterisk recognition is a discretionary political act. No state can be forced to recognize another. For example, many Arab states do not recognize Israel, and many countries do not recognize Taiwan, despite both fulfilling the Montevideo criteria. Conclusion. Recognition is the ticket for a state to enter the international arena. While the declaratory theory is more legally sound, statehood is a fact. The constitutive theory highlights the practical reality that without recognition, a state cannot effectively function in the international community. For an average student, it is essential to remember that recognition is more a matter of foreign policy than a strict legal duty.